Okay, so good afternoon from Jakarta. I hope that my voice is audible from your end. Thank you very much for all participants who have been confirming and also watching this live from KontraS's YouTube channel. As we are currently facing a very pressing condition at the moment in Indonesia, but it can also be a potential escalation for the shrinking civic space across Asia Pacific and also global terms. Now, based on the title that we have given in the invitation, in all sorts of publication from social media, that we are here today to hold a press conference for the International Solidarity and Justice for Fatia and Haris. Both are prominent human rights defenders from Indonesia, when they have stated actually a report based on a research done by 9 CSOs in Indonesia in terms of political, economic, and aligned with military deployment in Papua. But sadly, there has been no positive impacts or positive critiques coming to these civil society organizations, nor to Fatia and Haris, who were voicing out this report on a podcast done back in 2021 August, but instead they were put into criminalization process up until this moment, as both human rights defenders are now facing charges in the last indictment reading back in the 13th of November 2023 by one of the public officials from Indonesia, Luhut Bin Sarpanjaitan. Now, in this pressing condition, I am presenting two speakers. One, Dimas Bagus Arya, he is the coordinator from the Commission for Disappeared and Victims of Violence, KontraS. He will cover most of the presentations revolving around what has been going on for both Fatia and Haris in terms of unfair trial that they're facing at the moment. And we will also continue our discussion with Benny Agus Prima from Forum Asia, as he will cover about the shrinking civic space patterns, not only in Indonesia, but how it also concerns civilians, civil society organizations across Asia Pacific. So maybe I would like to give the first presentation, the floor to Mas Dimas. Mas Dimas, the floor is yours.
Okay. Thank you so much, Nadine, for the opening remarks. And yes, good afternoon for all the participants, both that joining in the Zoom and also that spectating via KontraS YouTube channel. So my name is Dimas Bagus Arya. I would like to give a brief and also a discuss regarding with the ongoing criminalization through legal procedures to two prominent human rights defenders, Fatia Maulidiyanti and also Haris Azhar. Both are a former coordinator of KontraS that very have a long journey and a long history for advocating and also promoting the value of human rights in Indonesia. I will start with my presentation. I will give you a brief regarding with the ODT that found or irregularity that found during the process of trials. And also, I would like also to emphasize regarding with the last hearing process with the indictment readings by the public prosecutor to Fatia and Haris, and what should we do in the next, and also what will affect in the Indonesian human rights promoting agenda in Indonesia, especially in Indonesia, and also in upcoming election in 2024. First, I would like to next slide, please. I would like to speak regarding with how the process of criminalization and also judicial harassment in our terminology was started. Nadine already emphasized it briefly in the opening that this situation was started by the publication of joint research by 9 civil society organizations in Indonesia to uncover the spider webs of conflict of interest involving the high public official and also the ex-military figures in Indonesia that also linked with one prominent name, which is Luhut Binsar Panjaitan as the coordinating Ministry of Maritime and Investment in Indonesia. The joint research was published and also disseminated through several mediums. There are dissemination in the form of opinion editorial via newspaper or digital media platform. There are also dissemination through podcasts. There are 2 podcasts, one by the coalition of Bersihkan Indonesia or Bersihkan Indonesia is the coalition that actually published and produced the joint research regarding with the political economy related with the military deployment in the Blok Wabu in Papua. So Haris and Fatia covered the research through the podcast in Haris YouTube channel. The name is Ngehamtam, which I don't know the terms in English, but the name of the channel is Ngehamtam channel. Was produced by Haris, and the podcast was published on the August 2021, discussing about mainly about the substance of the research and also uncovering several figures and several names related as a whole spider web of conflict of interest in this matter. And there is also seemingly tarnishing Luhut's rightful image, since his name was mentioned involved in the podcast as a person involved in the business. Fatia and Haris were sued by several laws, including Article 14 and 15, and also 14 and 15, the law number 1, year 1946. Very old law that still leads to Fatia and Haris. And also there is an article 3 of hoax, and also there is an article 27 paragraph 3, and also article 45 paragraph 3 also of the Information and Electronic Transaction Law, or ITA law in Indonesia. So there is a lot of we call it the architecture of fear or architecture of oppression by the state, especially using the law as a means to justify or the means to oppress several expressions and several critics involving the public official or state official that we found not only in the Fatia and Haris cases, but also in several cases that happening in Indonesia, at least during the second period of Joko Widodo presidency. We found there is also the usage of the same pattern to criminalize Rocky Gerung, one of the political scientists in Indonesia, that he's still ongoing in regarding with the examination by the police. And also there's a lot of activists, mainly the activists of labor rights, activists of environmental, and also activists for anti-corruption issue. So this is actually the design, the systematic design created by the regime, created by the state officials to actually build the architecture of oppression, or we call it architecture of fear, to demolish all the critique, the public participation towards toward the process of governance in Indonesia. Next slide, please. As for the Fatia and Haris cases, we also found several irregularity. And before I explain about those topics, I would like also to give an update regarding with the hearing. So Fatia and Haris have went through 28 total of hearings with the indictment reading agenda as the latest one. That we also found that it's pretty much become an oddity or irregular since there is one of the Supreme Court notes as one of the process of proceeding in the court in Indonesia that the court process should be minimum only 5 months to create the effective way of proceeding in the court, to create a very cheap process in the court. But we found the process of the Fatia and Haris trials already been for like about 6 or 7 months until now. And the indictment or the verdict will be proceed on the 18th December, approximately. Second one, the unfair trials and oddities are seen since the first hearing until the recent one. So there's a lot of oddity and also irregularities that we found and monitored, and I would like to speak and convey to you all in this afternoon after I presentate about the update. And the final one regarding with the hearing update is in the short panel of judges and also the public prosecutor standing of human rights theory or human rights value, as well as the current situation in Papua as a substance of Fatia and Haris mentioned in the podcast. So it's not only regarding with the situation in Papua, but all the legal enforcer, the panel of the judges, the prosecutor also didn't have any clue regarding with the theory of anti-SLAP or anti-strategic litigation against public participation. That's pretty much essential to defend or to protect the process or to protect the action of the human rights defender, environmental defender, to actually protecting the environmental, to protecting the democracy, and also to protecting the value of human rights. And also the prosecutor and also the legal enforcer in general didn't have any priority regarding with the corruption issue that was also stood by the civil society regarding with the conflict of interest that actually led to several alleged corruption by the public official, by several political persons, politically exposed persons, and also several state institution officials. So the police and also the public prosecutor didn't have any priority or didn't prioritize the process of corruption cases that was reported by the civil society. And besides that, and meanwhile, they keep pushing the process of criminalization against Haris Azhar and Fatia Maulidiyanti. So next, I will speak about several irregularities or oddities we found and we monitor during since the first process of hearing until the 28 process of hearing. So the first one, we also noted that during this process of trials, Fatia and Haris documents of cases was separated. This is against the rules or against the principle by the Supreme Court to guarantee the process of trials to be cheap, to be effective, and to be swift in Indonesia. Because in the Supreme Court principle, there are principles that has to be guaranteed by several panel of judges and also by district court to create the court that have to be cheap, have to be effective, have to be precise, have to be swift. But we found that the separation of the document created the undo process, a very long process, and this pretty much ineffective. This pretty much very buying of time, and there are several of things that pretty much against with those principles. The second point, we also noted that the first indictment made by the public prosecutor was flawed because there was a mediation process that should have been carried out unilaterally by law enforcement at the request of Luhut. This is actually pretty disheartening as well, because we found that actually Luhut was suing Fatia-Haris. He said publicly that this is regarding with his as a person, not as a public official. But we found in several occasions, Luhut also exerted or also created the situation that he also the public official as a minister coordinating of maritime and investment in Indonesia. So this is pretty much not or inconsistent, pretty inconsistent we found during the trials. The third point, we also noted that the prosecutor is very dominant and does not carry out his duties and function independently by distorting facts and undermining public participation in preventing corruption. We found that in several occasions during the trials, the public prosecutor always harassed the human rights defender profession, always harassed the pro bono lawyer that become the legal advisor of Fatia-Haris, also harassed the people and also supporter of Fatia-Haris, and also harassing the experts and also witnesses that was bring to the court by the legal enforcer or legal advisor or lawyer of Fatia-Haris. So this is a pretty sickening, and we found it's pretty much very odd. We found during the process of trial. The fourth point, we also monitor that as for the interim verdict agenda, the judge read out an interlocutory decision in which the judge did not consider the argument contained in the exception and also did not consider the letter from the National Human Rights Institution or Komnas HAM in Indonesia. Friend and journalists, I also would like to convey the fact that National Human Rights Institution of Indonesia also give the status of human rights defender by their internal regulation in Komnas HAM or National Human Rights Institution, and give the status of human rights defender to Fatia-Haris. And the effect should be the activist or environmental defender or human rights defender should be not become the subject of a legal issue or any kind of legal procedure during his or her activity to defending the environment or defending the human rights value. But we found that the panel of judges did not budge at all and did not consider it at all regarding with the document that was circulated or was tendered by the National Human Rights Institution. And this is pointed out that the legal enforcement in Indonesia didn't have any idea or didn't have any position on the human rights fulfillment, human rights respect, and also human rights protection in Indonesia. The next thing that I would like also to convey is during Luhut examination, we found that there is a several of cut off, or there's several of irregularity during the examination to Luhut that was being held in 8 June 2023, that there is a limitation of people to come to the court, civilians, diplomatic missions, media and journalists, and even several law advisor or lawyers of Fatia and Haris are not allowed to enter the court. This is the example, or this is the experiment that we found, that this is not Luhut as a person per se, but this is also the influence, or this is regarding with the position of Luhut as a public official, so that the court stop all the services, all the other cases during that day in the sake of Luhut himself, not as person, but as a public official, governance agent, and also minister coordinator of or of maritime and infestation of Indonesia. And this is pretty much become our main and biggest found of the oddity or irregularity during the Fatia and Haris trial. And the last thing that I would like also to convey is there is also the witnesses, expert witnesses, that was presented by the public prosecutor, the digital forensic expert, said that he had a proof from USB that Fatia and Haris did tarnish Luhut name, but the expert wasn't able to present the USB during the process of trial. So this is the things that are pretty much worsening and worrying, because there is like the symptom of unfair trial during the process. And the last thing that not mentioned during in the slide is we also found the habit of, and also the gesture of a panel of judges, that we've also found that the judges is pretty much passive. The judges pretty much didn't have any clue at all regarding with the issue of political economy, regarding with the issue of beneficial ownership. What is the concept of beneficial ownership, that also being the main become the main issue or substance in the research. Also, the panel of the judges didn't have any clue at all regarding with the theory of human rights, theory of anti-SLAPP or anti-strategic litigation against public participation, and even harass the human rights defender. So the whole package of oddities during the trial we found, and we also already reported to several institutions, several oversight mechanisms, Commission of Judicial, the oversight, the internal mechanism in the Supreme Court, and etc., etc. We already report the oddities. We already report all the irregularities to those oversight institutions, and yet we still didn't have any statement by the oversight institution up until now. So this is like the orchestration of, or this is like a role-playing game that was played by all the legal enforcement to actually punish and actually delegitimate the work of human rights defender in Indonesia, and we actually pretty much presume in the future that this pattern will repeat itself, and not only targeting human rights defenders, but also common citizen, all the common people that would like to express the opinion, would like to express critics to public officials or to state officials. Next one. I think this is the last one, the last slide. So during the 28th process of trial, which is the indictment reading by the public prosecutor, the public prosecutor was indicted Fatia for 3 years and 6 months in prison, while Haris was given maximum sentence of 4 years. So this is pretty much the fact we found that all the process of the trials actually and eventually punish and given a lot of harassment toward human rights defender, especially to Fatia and Haris, and there is no any kind of consideration made by the public prosecutor to actually lessen the indictment. And this is we found that the public prosecutor also have a bias and also very subjective during the indictment process, and thus we found that the public prosecutor have like a personal sentiment to Fatia and Haris. And the thing is, we found that actually, or if I allow to speak in this forum, that the public prosecutor is not to, you know, giving an order for the public matters, but serve as a lawyer during the process of trials against Fatia and Haris. So this is pretty much emergency and also pretty much SOS for the freedom of expression and also civic space atmosphere in Indonesia, because we found in the future, if this is not stopped, or this is the process, or the judges didn't give a maximum sentence to both Fatia and Haris, we guarantee and we actually foresee that this pattern of oppression will continue, will grow, and will target more and more civilians, more and more people, and also a party that very much different in opinion with the government official and also state official, and linked with the upcoming election, the process will be much more turbulent. The process will be much more chaotic if the process of judicial harassment and also the perspective in the legal enforcement didn't have any, didn't have any clue or didn't have any idea how to stop the process to actually criminalize all the innocent people and also all the human rights defender and environmental defender in Indonesia. And during this media brief as well, I would like also to humbly request to all the international media, international friends to actually spread this word, to support us, to guarantee the safe protection of the civil liberties, especially the freedom of expression, freedom of opinion. So, and in the future, we will actually guarantee the safe haven or safe space to actually conduct it all the human rights agenda or human rights activities, to actually encourage the Indonesia government to promote more and more the human rights, and actually will increasing the value of democracy in Indonesia. Thank you so much, everyone, and hope you already have one question, and I will gladly answer during the Q&A session. Thank you so much, Nadine. Back to you.
Right. Thank you very much, Mas Dimas, for your elaborated presentation on what has been currently actually happening to Fatia and Haris during their hearings. And one of the iconic hearings, if I may also add from Mas Dimas' statement, is where we have the expert examination of the ITE law expert, where he himself also stated in his objective and his perspective that both Fatia and Haris are just doing things. They were just expressing their not only opinion, but also the result of the research that they are, well, potentially spread the word, as Muslims call, to public, to civilians. The boomerang effect is actually negative and not positive, as we can see that the hearing is still ongoing at the moment. And I completely agree with your statement, Masimas, at the end, to spread the word, not only the updates of the hearing itself, but also spreading the word to two actually of the hashtags that is mentioned below in this slide, hashtag free Fatia-Haris and also hashtag stop criminalization. You have also mentioned a slight bit about the shrinking civic space pattern, which could potentially happen in Indonesia. And for that, we would like to give the floor to Mas Benny to have a further elaboration on the pattern itself and maybe further analysis of what the Forum Asia is currently doing at the moment for Fatia-Haris, and also to call out the international entities for this case. So, Mas Benny, the floor is yours.
Thank you. Thanks very much, Nadine, and also Dimas. Good afternoon, everyone. I'm Benny from Human Rights Defenders Program of Forum Asia. Forum Asia, we are a network of 85 human rights organizations across 23 countries in Asia. And today I would like to maybe add a little bit more to what Dimas has shared extensively. First of all, in Forum Asia, we think that the judicial harassment experienced by Haris and Fatia, it is not an isolated incident. It is definitely a part of the wider pattern where human rights defenders or voices of dissent are being systematically silenced by not only by the perpetrators, but also weaponizing the law that is available in the country to use it to attack the human rights defenders. And we saw this trend is continue to increase, and definitely the case of Haris and Fatia is emblematic to show how the civic space continually regressing. The direct criminalization against Fatia and Haris as a human rights defenders is also unprecedented because this is committed by a high-level public official that is not often happening in Indonesia based on our observation. And this actually will give grave implications for the freedom of expression because this will further create a climate of fear and also self-censorship, because it is inevitable that we cannot completely separate someone as an individual and a public official, especially at the caliber of a coordinating minister in Indonesia. We saw a pattern, for example, in other countries, like in Cambodia, where the prime minister directly attacking a media outlet. They might not do like any immediate action, but then the fact that the harassment is being conducted by a high level of public officials, it's not only has a legal implications, let's say in the court, but at the same time, it will create a public narrative that the human rights defenders, they are continue to be the troublemakers, trying to destabilize the country, affecting public order, and etc. So this is all a very, very dangerous narrative that is being played by the government, in this case, Luhut as the coordinating minister. So this is a trend that we note in many other countries in Asia, and unfortunately, this is becoming more clear in Indonesia. This pattern of judicial harassment, or in this case also, this can be considered as a SLAP, strategic lawsuits against public participation, as Dimas has mentioned, because clearly what Fatia and Haris did was sharing talking about the joint NGO report. It's a research talking about the mining environment, militarizations in Papua, which is a highly conflicted area. And by doing that, they are being targeted by judicial harassment using defamation. So this is definitely a SLAP case. Another trend that we note continue to increase in Asia, and especially Southeast Asia. And talking a little bit about Indonesia's international obligation. Indonesia has ratified ICCPR in 2005, And then freedom of expression is one of the core component of the ICCPR. It has a very high standard of protection of expression, and any limitations, it needs to be strictly and narrowly applied. And in this case, we at Forum Asia thinks it's not evident in the case of Haris and Fatia, because expressing views on public issues or potential human rights violations. In the YouTube video, they clearly talk about how the military might affect the operation and etc. So this is definitely has a very strong component of public interest, potential human rights violations. And whenever someone say about that, especially if it's coming from Fatia and Haris, where we know they are having a very long track record as a human rights defenders, they should not be criminalized. And the use of defamation law to counteract the criticism against the public officials, especially again, like I would like to remind that the one submitting the claim is a public officials, it's definitely disproportionate, and then it undermines the essence of freedom of expression. The issues that was discussed by Fatia and Haris, based on our analysis as well, it's fall into the public concern, and there has been a reasonable efforts to verify the truth. I think this is one of the key components that was mentioned by several experts related to freedom of expression, and how if it needs to be limited, like the limitation should be only happening if the reasonable efforts to verify the truth has kind of completed. But then in the case of Fatia and Haris, they cited credible reports by a joint civil society organizations. So we should consider what they said as a reasonable efforts to verify the truth. Hence, they should not be able to be criminalized. And another thing, like looking at Indonesia's international human rights commitment, it is even more important for the Indonesian government to push for this kind of case to not be continued or dropped, or even like similar case in the future should not be proceed at all. Because if we know recently Indonesia was re-elected as the UN Human Rights Council members, it means that Indonesia has even stronger moral responsibility to reflect the Human Rights Council principles when it comes to the protection of human rights defenders in the country. And in this case, it's not evident. And the irregularities that Dimas has mentioned earlier, it's becoming like even like a stronger reason for the panel of judges to acquit the defenders from all the charges. And we also note that the demand for maximum punishment is definitely excessive, and this likely might not happen if it's not the minister who submit the claim, because we saw I think KontraS, the lawyer team, have been live streaming the court proceeding every week, and we saw like how the argument was like being developed in the court, and a lot of media has also pointed out the irregularities of the statement made by the prosecutor or by the experts who were invited by the prosecutor. So if this continues and then Fatia and Haris are not acquitted, it will not only undermine the credibility of Indonesia at an international stage, but it will also set a very, very dangerous precedent for freedom of expression and human rights work in Indonesia. Because if these two HRDs with a credible report, they can be criminalized with such a severe punishment, then everyone might be affected by this at a later stage. So what we are calling in Forum Asia, we really urge the international community, the experts, the media to closely monitor and not only report about this, but also take action, call the government, send a letter to the government, to the judges as well, to make sure that they really consider the fact that has been laid out by the team of lawyers of Haris and Fatia, which clearly show that they are not guilty, and then the whole thing that is happening to them is an attempt of criminalization. And and lastly, to also note that again, this will set a very, very dangerous precedent and will significantly affect the situation of freedom of expression and civil society organizations in Indonesia. And yeah, I will stop here, and happy to answer any question. Thank you so much.
Right. Thank you very much, Ms. Benny. A lot of points have been stated there in your presentation. For example, Indonesia has this sort of commitment in the international society that they have ratified the ICCPR back in 2015, which also there in the International Convention includes the freedom of expression and opinion. So if this case is still ongoing and the judicial harassment is still faced by Fatia-Haris, so this is actually backlashing to Indonesia's commitment in the international moral responsibility. Moreover, where Indonesia have ratified the ICCPR, and you have also mentioned the bad or maybe becoming worse for the credibility and for the precedent in Indonesia when it comes to freedom of expression and opinion. If Fatia and Haris will have to face their charges after the verdict, we might also have one point there from your presentation. The case after the verdict or in this ongoing situation will craft a narrative from public officials to civilians across the nation or outside Indonesia that human rights offenders are causing chaos, as mentioned when charged to Fatia and Haris that they are troublemakers who are discriminating the state itself and also the public officials against civilians, which is fairly untrue since they have credential reports. And yes, I completely agree with both Mas Dimas and Mas Benny at the end of the presentation. If both Fatia and Haris have this sort of privilege that they are human rights offenders who have all of these facilities, for example, they have good law advisors who have been coming up into the hearings and giving all of their power there. What about those civilians who doesn't have any of these privileges? What about their rights to the freedom of expression and opinion? So great points from both panelists. And we are currently waiting for comments or questions from those who are witnessing this live on the YouTube channel or those who are participants in this webinar featured in Zoom account. So please, the space yours to have questions on the floor. Okay, there is a question on the floor by Arpa Mahardika. You may give your question. Okay.
Hi, Mbak Nadine. Hi, colleagues on KontraS. This is from Hardika from US Embassy, Jakarta. As you all may know, that we have been very closely monitoring and watching this case from day one. And we've just very curious what will happen at the end when the judges is going to rule out the decision. Do you expect that there is going to be a large, because previously we saw when Pak Luhut was on the stand as a witness, there is such a, I would say, for lack of better words, a blockage so that we cannot witness the trial itself. So do you think it's going to happen with the same thing do you think it's going to be a similar situation when the jury ruled out the verdict? Or will it be like a die down? Because as we know now, Pak Luhut is still under recovery. Do you think that there is going to be a more intense security when it comes to when the judge ruled out the verdict? That is one. And second of all, will the trial be open for everybody? We are planning to attend and planning to express our supports for both Fatia and Mas Haris as well. Thank you.
Thank you very much for your question. I see another hand rising, but I think I will give some time for our panelists to answer the question first by Mas Arfa. So Mas Dimas, I think the question goes directly to you. The floor is yours.
Okay, thank you, Mas Arfa, for convening the question. It's pretty, I'm happy to hear your voice once again. We've been long time didn't have any meeting. anyway, I would like to answer the first question. So we presume, and I think, yes, there will be a large of mobilization and there will be a large of, you know, quote unquote, blockade by the police institutions and police apparatus, because we found during the process of the 28 trials, which is the indictment reading by the public prosecutor, there is a mass of quote unquote again supporter of Luhut or supporter of that was anti Fatia and Haris, that also give a mockery, give like harassment during the process or after the process trial. So yes, we presume and predicted in the upcoming agenda, which is the shortest one will be into 2027, which is the treatment of the different of plea by the Fatia and Haris, and also verdict process, a lot of disruption. There will be a lot of problems, quote unquote. And the second question, yes, it's actually open. All the process of trials that was also regulated by law is actually open, because this is a criminal court and criminal cases, and I think it's not pretty sensitive. So yes, the answer is the process of the trial is actually open for publics. All of the spectators, all of the people that would like to actually seeing directly in the court is pretty much allowed by the principle of openness.
Okay, so I think I might add a bit from Mas Dimas. I think his connection is quite disturbed in the condition there. So just allow me to add a bit, Mas Dimas, that yes, the hearing is always open for public. Although maybe it has mentioned, as we mentioned before in the presentation, that, for example, in the examination of Rupiah Panjaitan, there has been a serious amount of closing gates and etc. When civilians, diplomatic missions, and others who want to participate in the courtroom. But still, we have not received any information that all of the hearing processes after the last indictment reading will be closed. So it will still be open for public, and we are actually also opening for arms for those who want to be participating in the hearing. We will have the plea agenda, as Dimas mentioned before, in next Monday, 27th of November. So for those who want to monitor online, we are always also open for the live stream through KontraS YouTube channel. From Jakarta News YouTube channel. We are open for that live stream every Monday in every hearing agenda. And those who want to also participate offline, please also come to the East Jakarta District Court in every Monday at 10 a.m. Jakarta time. So I think I'll just add to that. Next, before going to the Q&A feature we have here from Gerbert, but before we go to Gerbert, we would like to have from Clara. Yeah.
Hello, thank you. So this is Clara from the Human Rights Defenders team of the World Organization Against Torture. First of all, thank you for this presentation. It really helps to understand the context in which this trial is taking place. And I have a question because based on what you said, we can clearly see that on top of the judicial harassment, there are also attempts to stigmatize Fatia and Haris and human rights defenders in general. We see the use of these words that defenders create chaos, they are troublemakers, etc. and these can have an impact at the country level as well. So I was wondering whether this kind of discourse is permeating the society, the general public, or if it's for now, it's only restricted to the courtroom. And by these, I mean, if people, media, or others start to frame and label defenders using these words as well. Thank you very much.
Thank you very much for your question, Sarah. And thank you also for your participation. Maybe one of your questions are actually quoting from Mas Benny's presentation, if I'm not mistaken, in terms of human rights defenders' narrative could cause a serious chaos in the public and how it will progress after that. So maybe we could go to Mas Benny first, and after that, if Mas Dimas would like to add, please do. So first, Mas Benny, the floor is yours.
Sure. Thanks, Nadine, and thank you, Clara, for the question. Yeah, we note that there's an increasing narrative about negative narrative about what HRDs, especially in the media. We saw how, like in the cases of Haris and Fatia, every time it really depends on which media is reporting the news. I think if it's a bit more like conservative media, we know the pattern where the defenders will be automatically attacked, and it's not only happening in case of Haris and Fatia. And the most concerning part is also, I think, in Indonesia, the use of what they call as a buzzer, which is kind of like a paid people to comment, paid bots, etc., to populate the keywords and to build the narrative. We have seen this is taking place in the communities who are getting targeted for land grabbing, etc. In the recent cases, that there are this like online army, online trolls being systematized to kind of leave the comments in all the medias, etc. So if you are just a general public going to read this news, then it might be a bit easier for you to be influenced that, okay, this is the people who are protesting, the human rights defenders, these are the enemy of the country. So this is a very worrying trend that we note taking place, and definitely coming up to the election next year, this will get intensified. We have noted in the last election, the use of these online trolls has been massive, and then it's continued to grow. So yeah, maybe Dimas can say a bit more about the election context as well. Thank you.
Yes, I will taking over directly, Nadine. I would like to minimize because the connection is pretty much unstable in my place. So I will off cam. Thank you so much, Clara, for conveying the question. Yes, regarding with the restrictions. No. I would like to also to answer the first question regarding with the stigmatization. Pretty much same with Penny, but I would like also to highlight that there's also an attempt to demonizing the human rights defender activity in Indonesia by delegitimating the work of human rights defender. In these cases, I mean in the Fatia and Haris cases, there are several attempts to delegitimate and also to kill or to assassinate their character as a human rights defender, as a prominent human rights defender in the internet through the deployment of internet trolls that Benny already conveyed. There's a lot of buzzer, we call it buzzer, the internet trolls in Indonesia. We call it the buzzer is actually buzzing all the negative words in the Fatia social media, personal social media, and also in Haris personal social media, and also in GSO social media, for example, like KontraS. Always happen after KontraS releasing the content and we upload it in our social media. There is like a buzzing from the buzzer that actually would like to demonizing and also would like to delegitimating the fact that happened in the process of trial. And the second one, regarding with the restriction in the trials, yes, there is a principle in the court, but the people or the supporter or the ally of Haris and Fatia didn't violated any court principle, or there is no contempt of court violated by all the people that actually support and come to give a moral support to Fatia and Haris. But during the indictment reading by the public prosecutor feel that all the people that was actually supported Fatia and Haris keep giving a mockery, keep giving like insult to them. But in fact, we didn't actually regularly mocking them, quote unquote. We actually at least I'm personally monitored during the process trial. The people actually whistling something like that during the process that during the auditee that actually possessed or conveyed by the public prosecutor through the questioning to the witnesses, questioning to the expert, and also to delegitimating the lawyer of Fatia and Haris. So there's a reason. Hello?
Hello? Yes.
Hello?
You're all
Can my voice being clear? Yeah.
clear.
Okay, I'll continue. So there's a reason why people is actually whistling the public prosecutor, because the public prosecutor is actually conveying the problem themselves first. Thank you so much.
Right. Thank you very much, Mas Dimas, and also Mas Benny. Wonderful. No, not really wonderful as a good terminology, but great elaboration from the answer. Yeah, we have also seen Clara giving a response in the chat box. Thank you, Benny. And next, I think this is the last question so far from Gerbert from TFTP Philippines. Do you believe there is rape, abuse, and distraction committed by authorities in the case of Fatia-Haris? I think this also would go with Mas Benny's previous presentation. Again, if Mas Dimas would like to add after this, please do. Mas Benny, we will go to you first.
Thanks, Nadine, and thank you, Gerbert, for the question. I mean, I think based on what all the irregularities that Dimas has mentioned earlier, definitely we see that this is not a normal court hearing processes that usually took place. It really depends on who's submitting the criminal claim and etc. And I think when it comes to really assess the abuse of the discretion committed by the authorities, it's again, it's very much relevant to our call today to really monitor the situation, because we can make sure as a civil society, as a general public who want to try to make sure that defenders are not criminalized, and eventually general public will not be at the high risk of being criminalized for every single thing that they say in public. It's our work, it's our job to really monitor the process, create a pressure, like tell the Indonesian government and also the court that the international community is watching, to make sure that there is no abuse of discretion committed by authorities in delivering their verdict. I think it's on the 18th of December. So yeah, I think I can share it that way and my argument. Thank you.
Okay, I will take over, Nadine, directly. Thank you so much, Gerbert, comrade. Yes, there is like a grave abuse of the authorities that we found, that I also mentioned earlier, that this is actually pretty much very, there's a big power relation, because the persons that actually suing Fatia and Haris is still in power, still become a public official, active public official in Indonesia, and so and thus this is actually have a lot and a gap of power relation, and we always say during our statement in the public and in the media that this is actually the state versus its citizens. So how come the public official was not vulnerable to the critics? How come public official also creating the situation or building the architecture of oppression through the judicial procedure or judicial processes, and using or actually justified his power or his authorities by using the legal instrument. So this is actually a grave abuses towards democracy, not only in the human rights value itself, but also give a negative precedent towards the democracy itself. And I think there's also a discretion, abuse of discretion also by the authorities here, because again, Luhut was not portrayed mainly as a person or a common citizen, but he actually embedded as a public official and a strong person that have an authority. So yeah, there's a grave abuse and also a grave discretion abuse committed by the authorities in the case of Fatia-Haris.
Okay, thank you very much, Mastina. So I think that could include all of the questions so far by our participants. Gilbert also mentioned here in the comment section, Salamat, Benny, and Mas. With this, I would like to give several closing remarks as well as what has been said before in this press conference. First is that audits have occurred even since the first hearing. We can also see that up until this moment, both panel of judges as well as public prosecutor do not have any clue to those two things mentioned by Fatia-Haris in the podcast, which is problematic by both of the actors. First, human rights issues in Indonesia in general, as well as its iceberg. The second one is the Papua issue itself. They do not even try to dig deeper into the substance stated by the 9 CSO's report and published by Fatia-Haris through the podcast. Second of all, the case will just create a big climate of fear and will potentially contribute more to the shrinking civic space pattern in Indonesia as well as other Asia-Pacific countries, as well as other actors as well who are deeply involved, whether it is from the environmental human rights offenders and other issues revolving around human rights violations in their own respective countries. The third one is that it will craft again a narrative that human rights offenders are causing havoc, chaos, as they are troublemakers from the public officials to civilians. And Indonesia also, during this momentum, as well as back in the past where they have already ratified the ICCPR, and now they are holding this special position as one of the Human Rights Council members, which are holding this big moral responsibility when it comes to human rights fulfillment. But with this case, it's actually backlashing with that international commitments. And if this continues also, Fatia and Haris, where they still have to face charges after the third agenda, this will be a dangerous precedent on the freedom of expression, opinion in Indonesia. So the last thing that I would like to highlight from both of our panelists' presentation today, that Fatia-Haris will still have to face another agenda, the plea agenda on the 27th November, next Monday, 10 a.m. in the East Jakarta Court. We will also again live stream this through Jakarta Nikus YouTube channel. And there will also be verdict in the upcoming December, approximately 18th of December, but we will still have also to check the timeline. but still 18 December will be the approximate date for now. And we are also publishing the international support in the form of joint statement, which will be published by the Forum Asia website, and also a lot of other CSOs internationally, regionally, and also locally supported. It is there now in the slide. You may access the link below, sent by one of the Forum Asia colleagues. Thank you very much. You might also read several details of the statement there, also already being stated and mentioned briefly and also elaboratedly by Dimas and Benny. And yes, we will very looking forward to your international support, not only to monitor the ongoing case or the ongoing hearing, but we will love also to hear a lot of international support, giving letters to encourage the international, other international journalists, media organizations to push the Indonesian government to stop the criminalization of Fatia and Haris, because it's not only about Fatia and Haris, but it is about human rights defenders in Indonesia, human rights defender, activists, and other civilians who are just expressing their opinion, concern, as well as opinion and expression in their respective countries in their issues attacked. So yes, I think that is all for today's press conference. We will be looking forward to more agendas in this ongoing case and ongoing hearing for Fatia and Haris, free Fatia and Haris, and stop criminalization. Thank you very much and have a pleasant day ahead.
Thank you.
Thank you very much.
Thank you, Nadine, Benny, and everyone.